So, hello everyone, I'm Tom Stickland. I'm the Theatres Adviser at the Theatres Trust. Thanks for joining us today for this seminar on managing theatre organisations in financial distress. We appreciate that this is a potentially sensitive topic and as such have opted for a slightly different format than we usually use. Unfortunately, that means there's no chat function and you can't see each other, but there should be a Q&A box at the bottom of your screen where you can ask any questions that you may have. And there's the option to also ask questions anonymously if you want to do that. Today's session will be recorded and available on the Theatres Trust website. We'll be sharing the slide deck with you afterwards. This has been a tumultuous period for theatres and the people responsible for running them. Theatres Trust is the national advisory public body for theatres, and we're offering advice where we've identified needs in the sector. This is one of a series of seminars that we have run so far, and we're hoping to run more in the coming months. We're also happy to offer one-to-one advice where required. Today, we're specifically talking to the executives and trustees of theatres which are run as charities. We appreciate that many organisations have been operating in crisis mode up to this point, and key issues may have been missed or deprioritised. And I hope this will serve as a useful resource to help you get your organisation to a compliant state and in the best possible position to face what remains an uncertain future. I'm joined today by Erica Crump and Molly Carew-Jones from the law firm Bates Wells to offer their views on the key things that organisations should be considering. There's a lot to cover, so we'll take the session in two chunks. In each section, Erica and Molly will introduce some of the key issues, and then we'll have a short Q&A with them. So do type in questions that you have so that we can make sure this session is as useful to you as possible. Without further ado, let me hand over to Erica and Molly to introduce themselves and the first batch of issues.
Thanks very much. So my name's Erica Crump. I'm a partner at the law firm Bates Wells. We offer lots of things, but I guess our USP is that we're leaders in the area of advising charities and social enterprises. And I'm lucky enough to lead our culture and creative work. So that means I advise a lot of theatres, cultural charities, museums and galleries. And I'm also lucky to work with my colleague Molly, who can briefly introduce herself as well.
Hello, hi, yes, I'm Molly and I'm a solicitor at Bates Wells, working with Erica in the charity and social enterprise team. Been advising a wide range of organisations as they try and cope through the current uncertainty and that's been caused by the crisis, and obviously the huge impact it's had in particular on the arts organisations. So hopefully we can give you some helpful pointers and tips to get through these next few months.
Great, so this has to be an overview. This is what we're covering today: governance, commercial relationships, trading and trading companies. Then we'll have a pause, and then we'll look at it more from a financial perspective, and particularly organisations that feel they're moving into financial distress. We'll look at insolvency and going concern, and we'll look a little bit at crisis decisions options. This is a really broad church of subjects, and it's fair to say that we came up with this list because they seem to be common themes that a lot of cultural charities, and it's important to note that we're focusing on charities, so it's a lot of theatre charities or visual arts charities came to us with these sorts of questions. At the beginning of the crisis, there was a lot of contact and discussion with boards of trustees, committees and senior executives about how to even make decisions during the crisis, and also about what to do with their body of contracts, both looking backwards and going forward. And then obviously some of those discussions have moved into more serious discussions around the possibility of not being able to continue, either not being able to continue in the form that they operate in now, or in some cases having to think about winding down or other drastic options like merger or part merger. So we're going to take you through some of these topics, present on them very much as an overview, and with a caveat that we are not, for example, insolvency experts or accountants, but to try and give you a flavour of those issues. And then there'll be appropriate pauses for Q&A and some discussion between ourselves. So I wanted to start with governance and good decision making during a crisis, I've had a lot of discussions over the past few months with boards of trustees, particularly how they might relate to the executive and how on earth they make decisions at a time where their strategy has often been thrown out of the window. And that obviously leads on to what is our potential vulnerability as a board. And that discussion often focuses on the trustee duties, the broad legal duties that, if they are breached, can cause issues with charitable entities, both with the Charity Commission and, in a worst case scenario, potential legal liability. So we don't have time to look at this subject in detail. It's worth saying that the Charity Commission has very good guidance on trustee duties and also on making difficult decisions in times like a crisis. So I encourage you to look at the It's Your Decision guidance. But to take a few of the trustee duties, the overarching one is for the board to act in a way that will advance the charity's purposes, in a way that they think in good faith will advance the charity's purposes. And the difficulty you've got during a crisis when there are lockdown rules in place is that all of those ways that typically a theatre charity would advance the purposes, which are typically advancement of education or advancement of culture and the performing arts, have been brought to an end. We can give a lot of comfort on that as charity lawyers, because ultimately there's nothing in law that says you need to be doing a minimum number of performances. And provided you're still working towards recovery and public benefit and advancing those purposes, it's not an issue. You still are going to need to create a trustee report the next time you file accounts. And when that covers the period that crossed over with the crisis, of course, you still are going to need to talk about how you advanced that purpose and satisfied public benefit. But you don't need to state that you had activities during that time. And for example, if everything you've been done has been reduced to a bit of digital activity, that also still validly does advance your purposes and the public benefit. There's also the angle of other trustee duties around looking after others. And one of the key trustee duties is to protect those to whom you owe a duty of care. So that includes the public, the beneficiaries, the people who are coming to your theatre, and then your staff as well. There's always nervousness as a trustee, like, do we need to be perfect? Do we need to be experts? And absolutely not. You know, the Charity Commission makes clear, the court has made clear, you don't need to be perfect. You just need to act reasonably and prudently with care and skill. If you have particular expertise, it is true to say that you will be treated with that level of expertise in mind. So my reasonable care and skill, my trustee duty, is different to people who do not have a legal background. I would be held to a higher area of account. And that can feel vulnerable, particularly for accountants who are sitting on boards or lawyers who are having to grapple with some of the issues we'll talk about today, such as going concern. And the only other one I would mention for the purpose of this talk, but of course, please do go to the Charity Commission website and read up on the duties, is to always go back to the governing documents during the time of a crisis to check you're in line with it, the things you're doing still comply with it. If you've got to make decisions at speed, still ensure that you're managing your conflicts, not least because you may need to go to the Charity Commission during the crisis to explain some of the situation that you're in. So leaving the duties to one side, there's a lot of practical questions that came up, particularly at the beginning of the crisis, of boards coming to us and saying, we only meet every 3 months or every quarter. And it is very common for the board to delegate down to a committee. So most of the cultural charities, theatres, galleries that I work with have a crisis committee and will continue to do so for a period of time. And that can cause a bit of a friction between the wider board and that smaller group, often that is made up of the executive and some board members. But a key legal point to take away is delegation is fine. Just make sure that you properly document it. Ensure that the trustees and that committee understand how they should be communicating with each other. As a trustee, if you're not on that committee, accept that you're not going to be able to be involved in every decision, but ensure that when decisions are made both on the committee and at board level, that you're recording those decisions and the thinking behind them. And I mentioned Charity Commission guidance, but it is really worth reading the guidance on decision making, because if you can reflect that approach to decision making during the crisis in your minutes, that will stand you in good stead should they need to be looked at by the regulator at a later date. Now, I just wanted to bring Molly in here partly because she's got particular experience with reporting things to the Charity Commission, to just talk a little bit about the regulator.
Yeah, just quickly, and as Erica said, we're on a whistle-stop tour, so we won't go into too much detail now, but please feel free to ask questions. But for those theatres that are registered charities and are therefore regulated by the Charity Commission, there is a duty to report serious incidents that affect your organisation. This isn't a duty that only arises in the current crisis. This applies all the time, and essentially there is guidance on exactly what qualifies as a serious incident that should be reported. But broadly speaking, it's an adverse event that results in or risks significant harm for your organisation, and that harm can be harm to individuals such as beneficiaries or staff. It can be reputational harm, or it can also be financial harm. So taking the current situation, clearly the lockdown and the implications of coronavirus is an adverse event that has resulted in financial loss, financial harm to a huge number of charities, not just arts organisations, but really charities across the board. And early on in the crisis, the Charity Commission, first of all, released some very unhelpful and unclear guidance, which they quickly revoked, but then released very short guidance essentially to say that they are, as a regulator, they're attempting to be flexible and pragmatic in the current situation, and they're not expecting all charities to submit a serious incident report just because they've had to shut their office or because they've had to stop current activities as a result of lockdown restrictions. However, what the Charity Commission would expect you to report would be if the implications of the current lockdown and the current crisis are so significant to your income that there's a real chance, a real risk that you are no longer going to be able to continue trading, that basically the financial loss is so significant it's going to potentially affect your solvency. Now, in practice, it's also worth bearing in mind the fact that you need to be kind of forward thinking, and the fact that if you had qualified accounts, which is an issue that a lot of organisations are going to be facing with their auditors unable to verify that you are a going concern, and they might have to qualify the accounts on that basis, that they can't make that assurance. If that happens, that immediately triggers a need for a report from the auditor to the Charity Commission. And we have been talking to some organisations about whether it is therefore sensible, if an organisation thinks they're going to be having qualified accounts, if they should then be preemptively submitting a serious incident report to the Charity Commission, just giving them kind of starting on the front foot and giving them a heads up that there is likely to be that they should be expecting that report, and therefore kind of preempting and preventing any questions or concerns when that later report from the auditor goes in. And that is what we are suggesting to a number of organisations if they think they are going to be in that position, just because in general with the Charity Commission in relation to serious incident reports, being open and upfront and being on the front foot nearly is going to put you in a better position than them finding out about something through a third party and coming to you with questions and being caught off guard. And as a general approach to the Charity Commission, that's what we recommend in relation to reporting. And I think on to the next slide. Yes, sticking with me here. So these are basically just we don't have time to kind of go into a lot of detail about how you should be approaching your contractual and commercial relationships in the current circumstances. However, we have included a checklist there for kind of key clauses that you might want to consider if you're kind of reviewing and going through your contractual relationships. I mean, with the current uncertainty and everything that's happening at the moment, a lot of organisations are using this as an opportunity or a time to really go through key contractual relationships, not only to figure out what potential liabilities you have and what obligations you have coming up in case there's a risk that you might not be able to perform those, but also having a a kind of understanding of what potential income you have around the corner, and and essentially being able to prepare for the future as we kind of go into another period of more uncertainty. And just some of the key provisions that we wanted to touch on now is that it's important to note that if you did try to purport to end a contract or walk away from a contract without having a legal justification for doing so, that would then put you in breach of that contract, which then puts you at risk of a breach of contract claim, and you could be liable to the other side for financial losses that they suffer as a result of you breaching that contract and kind of wrongly trying to terminate. So these are kind of a checklist of provisions for you to work through, which obviously will provide information about not only what you're obliged to do under the agreement, but also when you can walk away. And provisions that came under a lot of scrutiny as a result of the current situation, which I think is fair to say had not been in at least the time when I've been working in the legal services, had been subject to this level of scrutiny, was the provisions that are referred to as force majeure. And that's something we advised a lot of clients on. And essentially a force majeure clause is a clause that sets out what happens when an event occurs that is outside of the control of both parties and results in the parties being unable to meet their contractual obligations. And there is no general common law interpretation or application of force majeure. So whether there is a force majeure clause applies, it will depend on exactly what is set out in the agreement. And you will want to check, one, if there is a force majeure clause in the agreement at all, and if there is, what that says and what the consequences are. And it will, as I've already said, depend on exactly how that clause has been wording. And historically, these clauses were kind of thought of as a boilerplate clause, perhaps not given much thought in contractual negotiations, but now are coming under a lot of scrutiny. So it's worth checking not only the force majeure clause of contracts you're looking to walk away from now, but also perhaps reviewing your templates and agreements going forward to check whether these force majeure clauses are fit for purpose. So generally, if a force majeure clause is triggered, depending what's written in the agreement, but it's quite often that the obligations of both parties will be suspended, and along with any liability for non-performance while that force majeure event occurs. Obviously, a question that we've been looking at a number of times is the current situation, the lockdown, the pandemic, is that going to be a force majeure event? And again, it will come down to what a force majeure event is defined as under the agreement. It could be really broad, and it could be any circumstances outside of your reasonable control. But it's worth then considering, well, what is it that you cannot perform? Can you strictly not perform that because of the pandemic? If, for example, if it's just that you're required to make a payment, there's not actually anything as a result of the pandemic that means you can no longer make that payment. Whereas if you can no longer deliver an event, you can no longer open your doors, then that's obviously something that actually is preventing you from meeting your contractual obligation. And also there are then, of course, force majeure clauses that may specifically refer to government restrictions or pandemic and those kind of things. And so it doesn't have to expressly refer to the current situation, but there may be, depending on the wording, the current situation may not be caught. And it's also worth noting that historically force majeure clauses aren't particularly well drafted, and they often don't cover what happens to funds that have already been paid or liabilities that have already been incurred prior to the force majeure event. And also it may only give restricted rights to terminate. For example, only one party may have the right to terminate if they are able to trigger that clause. So it's definitely something that's worth investigating and looking at, but it really is going to come down to exactly what's on the piece of paper. And another contractual doctrine that has been very relevant to the current situation is frustration. So frustration is something when occurs when, after the contract's been entered into, something happens which renders that contract basically impossible to fulfill. So it's no longer possible for the parties to fulfill their obligations. And there's all sorts of really some of the more interesting contractual case law about what actually is frustration, and a lot of the situations are relevant to do with kind of arts organisations, such as music halls burning down, so they can no longer just have an event that they had contracted to perform, or if there's an unavailability of a named performer, if they're unwell or if they've died. Or if an event was, there's a famous one where it's an event that was held for a coronation where actually the coronation doesn't go ahead, so they can no longer have that event that they were planning to have. But frustration, it it is somewhat limited in that it has to really, the test is whether it becomes impossible to deliver those obligations. And also you can't rely on frustration if there's another clause in the agreement that already covers off what would happen in that situation. So if you have a force majeure clause that applies, the doctrine of frustration will no longer be helpful. If frustration does apply, what that means is that contract just dissolves permanently, and the parties are then excused from performing any future obligations. And in most cases, any kind of liabilities and money paid before the frustrating event will become recoverable. So frustration arguably can be more generous, but force majeure clauses, if properly drafted and if properly thought through, can be extremely helpful. And it's definitely a provision that's worth revisiting in your commercial relationships. And I'm conscious of time, so I won't go through the other points, but just to note that we just put at the end of the slide there, obviously negotiation with the other parties is going to be key through all of this, and being in contact with your suppliers and your parties that you're contracting with, and seeing what can be agreed. And we are seeing quite a lot of flexibility from organisations at the moment, because obviously a lot of people are in the same boat. People aren't wanting to go to court if they can avoid it. So be aware of your rights and your abilities to walk away, and have a full understanding of your agreement, but always consider how best you can negotiate with the other side as well.
Thank you, Molly. So I'm just going to quickly mention trading subsidiaries. This isn't a talk about why we have trading subsidiaries, but it is worth quickly reminding ourselves that the majority of cultural charities will have a trading subsidiary, and practically all of the theatres I have worked with do. And that is because, for the simple reason, in most cases, that if a charity is trading in furtherance of its objects, so typically selling tickets to events, or in many cases, because a lot of theatre charities are also educational, holding educational events and receiving fee income for those. If profit is made on those activities, it is not subject to corporation tax. But all of the other trading that theatres like to do, such as selling merchandise, holding corporate events, hiring out the building, entering into long-term corporate sponsorship deals, etc., does not further the charitable purpose. Often it would be a breach of trust and a breach of the governing document to enter into that activity via the charity, because you would incur unnecessary tax. And the reason why it's unnecessary is that activity could be carried out by a wholly owned trading subsidiary, and HMRC accepts that if that trading subsidiary makes a bulk of profit on that non-charitable trading activity, it can gift it up to the charity before tax is due, and corporation tax won't need to be paid, creating a circular tax efficient model. So most of the cultural charities out there have a trading subsidiary, probably with a deed of covenant in place, and often with a resource sharing or framework agreement setting out that the charity is very much in the driving seat and that profit will be paid up. So that's all good in normal years, and it's fair to say that, you know, a successful trading subsidiary is a little bit like the jewel in the crown of a diverse mixed economy model for cultural entities. Funders love to see a healthy trading subsidiary. So far so good. And then the crisis hit, and I've had many calls from either trading subsidiaries or from trustees who have an interest in the trading subsidiary, obviously, or executive team members saying for the first time the trading subsidiary is literally not going to turn any profit. It may be trading at an extreme loss. We don't want to close it down. We don't want it to go insolvent, because we know we're going to need it to trade our way out during the recovery phase. What do we do? And without going into all of the different options here, a charity does have quite broad rights to support the subsidiary for a period of time, and it can do that in a number of ways. It could waive rental payments, for example. It could waive payment for resource under a framework agreement, for example, if you're sharing staff. It could effectively loan funds down to the subsidiary on the basis that it will be repaid. It could enter into some other type of social investment into the trading subsidiary, or it could even make a grant down to the trading subsidiary if the trading subsidiary is carrying out charitable activity. So all of that stuff is possible, provided it is properly documented. So, for example, a loan agreement might need to be put in place that is secured, or an investment agreement, or if you're waiving payments that need to be made from the subsidiary, it should effectively be treated like a loan. So there's lots of different ways of structuring that, and it's important that it is properly recorded and set out in writing. Otherwise, you could be in the danger area of subsidising non-charitable activity. But to reassure you that those methods are in place and that lots of charities are thinking of that. And I think my main takeaway of when you're deciding to support a subsidiary for a period of time in the best interests of the charity is, firstly, make that decision in the best interests of the charity. You can obviously see why often it would be, so that you don't lose the subsidiary. Record the decision and ensure that you're taking the decision properly in accordance with the articles or the constitution. So manage the conflict when you're making that decision, because often there's a real crossover between the charity board and the trading subsidiary board, and so there's a bit of a conflict there. And so that's really all I would say on that. It's a hot potato. Lots of people are asking, what do we do about our trading subsidiary? Should we close it? And yes, that could be an option. And it could be an option if you need to shed part of your business or make, for example, redundancies. But equally, there are many options to support it for a period of time, provided that's reasonable and in the interests of the charity. So I think that brings us to the end of our first whistle-stop tour about governance, some of the commercial aspects and the trading subsidiary relationship. Let's take a pause there before we go into the other subjects, which are more focusing on the financial difficulties piece, and have a chat about some of these themes maybe.
Great. Thank you very much. Yeah, lots and lots to think about there. It seems like a common thread through all of these is all about making sure that you're documenting your decisions and that you can justify that you kind of considered these things thoroughly before making the decisions. Has there been any issue with trustees meetings going digital rather than rather than happening in a room, or is and how you document those actually happening?
So it's amazing how quickly trustee boards have moved to kind of Zoom or Teams meetings, and most of the ones that I have been involved with or provided support on are still able to do all of the normal stuff of having effective discussion with each other and proper minute taking. I think there have been some issues with some boards where people are not particularly technologically savvy, and there are often options then under the constitution to take decisions in a different way as a board. So, for example, to take them by email. What I would say on that is I wouldn't particularly encourage that where it's difficult crisis decisions, because I think the Charity Commission would feel, and a lot of good governance guides would also state, that that's a kind of last resort if you really need to take a quick decision, because the trustees, who are collectively responsible as part of their trustee duties, don't really have a chance to engage with each other. And then you can't write down the key points of the debate and the discussion. So it leaves you a bit more vulnerable about that decision at a later date. For example, if you're thinking about loaning down a large chunk of money to a trading subsidiary, I'd prefer there to be a proper board meeting that talks about the pros and cons of that, talks about why it complies with X, Y, and Z guidance, and then properly records that decision rather than a quick email around.
I think I'd also just add and it applies to all board minutes, all times, but particularly where you're taking decisions in relation to a crisis or something that's kind of particularly high stakes, is if you view the minutes and draft the minutes with an eye on it, what would these look like if they were going to be put in front of the regulator, if they were going to be combed over by the Charity Commission? They should essentially act as a defence and a justification for the trustees as to their decision. So if it just says board discussed proposal, board agreed to make loan to trading subsidiary, whatever it is, there's no real explanation for or justification for why that was a reasonable decision. And as Erica says, you definitely don't have to be perfect, and no one's expecting that, but to be able to present these minutes.
Oh, we just lost Molly and she froze. Is that just on me or?
No, I think that's that. I thought it was me briefly, but let's. Are you back there, Molly? You're back.
I'm back, sorry, but I think I'd finished.
So the often a lot of our a lot of theatres operate with a high degree of delegation to their senior executive team, and in this time there could be a tendency for trustees to want to get very involved in the decision making. Have you got any advice on how they might kind of balance the right level of scrutiny with not putting too much pressure on their senior executive team to be able to create board reports at a short notice?
I think this is a real issue of extreme fatigue of executive team members, partly due to the number of committee meetings and trustee board meetings that they need to go to, and an understandable nervousness of the trustee board, who, you know, probably were having a swimming time and for the first time are thinking about going concern test, possible insolvency, complete change to the strategy. I think my advice is that, you know, the trustee board has to understand that they can't be involved in everything, and there has to be a level of trust. Whilst I think it's really important to have nice board papers that explain all of the thinking, that the reality is that decisions are going to be made at speed. So there has to be an understanding that it might not be as polished, and that there is not an expectation to be perfect. And it's a general governance point, really, that the board is there, has delegated management responsibility to the executive in most cases. And of course, they can set up a separate crisis committee with some trustees for this period of time. But they have to be careful about getting into the weeds of some of the nitty gritty if it's not essential to strategic decision making, because the last thing that's needed at the moment is getting dragged into points that are not kind of central for surviving the crisis. But it's a tension, and I understand it from both directions. Yeah,
absolutely. The serious incident reporting that you were talking about, Molly, I think a lot of trustees will now be suddenly thinking, oh, is this something we should be filing right away? Is this what's the bar for when is a time that it should be submitted? And is there something that trustees, and what should trustees have considered kind of prior to submitting it? Do they need to come in with a justification of and how they're going to deal with this serious incident, or is it just the fact of kind of raising a flag to say there's a concern?
Yeah, so I mean, it's the guidance in one sense is very helpful in that it gives kind of a breakdown of what the definition of a serious incident is, but on the other hand, rather unhelpfully, it isn't a definite. It's kind of at the discretion. Is ultimately a decision for the trustees as to whether a serious incident report is required, and whether the financial position or the repercussions of the current crisis have had such a significant effect on the organisation's finances that it therefore justifies a serious incident report, because the test is whether it is significant in the context of your organisation's operations. So like a £5,000 loss to a very teeny tiny charity is going to be huge, whereas to a household name is not going to be kind of as much of an implication. So there isn't a kind of a one size fits all. But as we said, we are suggesting that organisations who are going to later down the line be having to make a report to the Charity Commission because of qualified accounts, a safer approach is to kind of get in there first and kind of make the Charity Commission aware of that in terms of what you need to include in that report. So you make the report using an online reporting portal which has specific questions that you answer, but I think it's fair to say that you should be provided the more information you can provide to the Commission about what steps you are taking to manage the situation, and essentially you're demonstrating to the Charity Commission that you have things under control, and that you are keeping things under review, and that you've got an executive team or a crisis team that are managing things appropriately. That's the type of things that the Charity Commission are going to be concerned about, kind of good governance and making sure that you're keeping an eye on things. You're not expected to control things that are outside of your control, and there is uncertainty at the moment, and I think it's perfectly reasonable to say that there are some unknowns in the upcoming months, but just showing that you have the processes and governance framework to be able to manage and oversee the situation is what the Charity Commission are going to be interested in.
It's also worth noting that this approach to serious incident reporting, although it's always been there as an obligation, changed very much around 2 to 3 years ago, and it became much more of a thing that the Charity Commission was encouraging charities to actively do. If you speak to any charity that works internationally or in safeguarding or maybe in education, many of them will be on a yearly basis reporting lots of things to the Charity Commission because it's become very much part of what they do. A lot of them will bulk report many incidents, which could be anything from financial through to safeguarding, etc. As I have a particular focus on working with cultural and education charities, they haven't quite caught up with that, partly because the need hasn't necessarily been there. So it still feels like a scary thing, but it shouldn't. I mean, on balance, I would say for larger charities, if they never report serious incidents, that is probably more of a concern to the Charity Commission than if they do occasionally. So please don't be scared about that. I think the Commission is appreciative and understanding of the position that cultural charities are in.
Yeah, that's great. Very useful to know. Moving on to contracts, it feels like there's probably quite a different treatment of contracts that happened in a period when theatres were unable to open by restriction versus when they were potentially able to open but under social distancing restrictions that would limit the viability of their performances. And I suppose that's just something, it's not really a question, I don't think, but just checking that you agree that you think that theatres will probably need to consider kind of two different approaches there, and to flag what you said about the negotiation being key with the contract holders, because that's certainly what with the other parties, because yeah, that's certainly what we've come across in our advice there is.
Yeah, and I think that, you know, it's amazing how people kind of forget. So often I see contracts for something for the next few months and they're put before me, could I have a quick look? And they're actually not dealing with any of the things that Molly was talking about, because a template will be used and people forget. But it's completely foreseeable that for the activity that any theatre is or even their trading subsidiary is planning, it's uncertain. We don't know how it will pan out, and it's very likely that it will need to be delayed. But the contracts templates are not drafted on that basis. They're drafted on the basis of certainty. And so it is about doing some bespoke drafting to say, and this may not happen at this time, and that wouldn't be a breach, but if it actually is delayed for 5 or 6 months, it would be. It's about doing that thinking now. Otherwise, we'll be back where we were in March and April, where everyone's in breach and trying to negotiate a way through that.
Mm.
Absolutely, yeah. And I think the things that were being said about trading subsidiaries is probably affecting a lot of theatres as they see kind of a model that probably the separation has not always been distinct and clear of the subsidiaries' decisions and those of the trust, and that kind of separation suddenly becoming much more important at this time. The question I had was around loaning to subsidiaries, and do trustees need to consider the likeliness of the repayability of such a thing, and would it be a breach to not do that?
Yeah, you do need to think about repayment terms, but also typically a loan to a trading subsidiary is on generous terms. The Charity Commission has some guidance called CC14, I think, which is the guidance on social investment. It also sets out that if you're making that loan and the trading subsidiary is, for example, really contributing to your social mission as well, even though it may not be strictly charitable, there's scope then for even more generous terms. So yes, you need to think about it. You can probably be more generous than you would in a strictly commercial setting, but it does need to be set out, and you need to look at that Charity Commission guidance before entering into a loan agreement, which says you won't ask for repayment for 20 years, which just isn't an arm's length relationship. So yes, it all needs to be thought about and then documented.
Great. I think we should move on to the funding issues now. So if you'd like to give us a quick introduction of this next set, that'd be great.
Yeah, sure. I will again go very quickly through this in a kind of an overview of some of the key issues that are coming to us from kind of particularly our arts and cultural clients. So kind of as mentioned, with the ongoing uncertainty and that we're experiencing at the moment, it's vital that trustees have a clear understanding of their organisation's financial position, and it is a time now to kind of review your income and your expenditure, both now and kind of for the upcoming few months. Just to know, I don't know how many kind of people we have here today who are perhaps listening to this on a recording are from unincorporated organisations. Probably not that many of you, but just a quick note that obviously the stakes are higher when you're working, when you're a trustee of an unincorporated entity. When you've got a corporate entity, that entity has its own legal status, it's a legal person, and it can directly contract with third parties and incur its own debts and liabilities. And the trustees aren't going to be liable for those liabilities unless they have behaved in a way that's going to amount to a breach of their duties, and in very limited circumstances. Whereas unincorporated organisations, you don't have a separate legal person for that entity. So the debts of the organisation are the debts of the people who incurred them, who are therefore the trustees. And if there's not enough money in the charity to pay those debts, those trustees can be personally liable. So it is it's a higher stakes when you are dealing with an unincorporated organisation. So this slide here, I'm not going to talk through everything, but just list some things that organisations are doing to kind of keep on top of their financial position. We've already talked about reviewing contracts and kind of upcoming income and expenditure. Staying in touch with funders is quite an obvious thing, but is really vital, kind of maintaining those relationships and the goodwill in those relationships. We're seeing a lot of flexibility with funders at the moment, and obviously they have a lot of sympathy and understanding for what cultural organisations are having to cope with at the moment and how difficult it is, and there may well be flexibility in relation to kind of the use of funds that you've received. There's also consideration of reducing your costs. A lot of organisations will be taking advantage of the furlough scheme, which I understand now is continuing until March next year. And then it's also a perfect time, really, not perfect, it's only not ideal, but it is a time where a lot of organisations are considering they're using their reserves, and those reserves are there obviously to support you in times of crisis. And where a lot of theatres and arts organisations couldn't have survived over this period, over this year, and they're having to shut down for months at a time if it wasn't for the reserves that they had available. And of course, kind of this touches on the issue which is on the next slide here, is that a lot of organisations they've got money in the bank, but it's then a question of whether that money can actually be used in the current circumstances, or whether that money is restricted for a specific purpose. So it is, this is quite a specialist area, particularly when it and I just want to put out that this is certainly something we're getting a lot of people come to us about, but it is probably an area where you are likely to need more specialist advice if you're actually looking at specific restricted funds that you have in your books. But just to highlight the difference between designated and restricted funds. So if you've got a designated fund, they're funds that are part of your general funds, but the trustees have essentially decided to earmark or set aside those funds for a particular purpose. So a common example of when this might come around is where if you've received a legacy that includes a kind of expression or a wish by the donor that their funds are used for a particular activity, but it's not actually there's not a binding legal obligation to use the funds in that way. It's just that the trustees may have decided to respect those wishes and designate those funds accordingly. So if you're dealing with a designated fund, the trustees can at any time decide to undesignate those funds and use them for the general purposes of the charity. So that's really, really helpful. A restricted fund, on the other hand, is a fund that has legally binding restriction on how it can be used. And that restriction is typically set out in the kind of the governing document that's established that gift. So that would be a deed of gift perhaps, or a will, perhaps a letter accompanying the donation. And there's basically two types of restriction that you might be dealing with. You might have a restricted income fund. So that means that those funds must be applied for the specific purposes that are set out. And that is typically going to be narrower than your general purposes. Or you might have a restricted capital fund, which is also known as permanent endowment. And that means that the gift must be the original gift, it needs to be invested to produce an income. And then as a permanent endowment, you'd only be able to use the income. You wouldn't be able to spend the capital of that fund. And just to note that in our experience, and particularly recently, we're getting organisations asking us to consider the terms of gifts, and they're revisiting how they've kind of classified various funds they received. It's very common for funds to be incorrectly categorised, and we often get people coming to us saying, oh, I've got this permanent endowment and we're not sure how we can continue meeting this, and then we look at the original document and actually there isn't a firm restriction set out in the original governing document. It is just that the trustees have decided to use those funds as such, and actually they can undesignate for that purpose. So it's definitely worth revisiting the restricted and designated funds that you've got available, because it may be that you've got more flexibility than you thought you had, and you may be able to use those funds in ways that you didn't think that you could. There is a power if you have got a restricted fund and you're finding that it's actually no longer possible, it's just impractical to use those funds for the original purpose in which they're given. Trustees have a responsibility to make sure that their funds are put to effective use, and if that's no longer possible, it is possible to change a restriction. I won't go into the kind of the details of the process that you need to follow, but essentially, generally speaking, you'd be looking at the original governing document and seeing if there's any mechanisms to change that restriction. It may be that those mechanisms don't exist or are not applicable, in which case there is powers under the Charities Act 2011 that may be able to help. There are certain conditions you need to meet, and in most cases you'd be looking to get Charity Commission consent as well in order to do that. And if the powers under the Charities Act 2011 still don't help, there is another route that you could take, and that you could apply to the Charity Commission to make a scheme that would enable to use those funds for a different purpose. But as I said, in most cases, you'll be looking at Charity Commission consent. So it's not a quick process, and it's obviously worth making sure that you're kind of documenting your decision to do this, and the reasons for why you can no longer use those funds in that original way has been kind of clearly recorded, and you can explain that to the Charity Commission. As kind of more general considerations, you also need to be considering what the long-term impact is of making any changes to those restrictions, and also checking whether you need to obtain donor consent, and the potential for kind of, is it going to damage any ongoing relationship you have with that donor, or any potential reputational damage. So there's kind of those wider issues that need to be considered as well. But just to note that now is really the time to be looking at these funds and seeing if it gives you that kind of much needed injection of additional funding, if you can access those funds that perhaps you hadn't been using previously.
Yeah, I mean, there's a huge piece, isn't there, about keeping close to major donors and discussing the current situation with them without wanting to alarm them, and setting the groundwork, if you already haven't done so, for releasing restrictions, or for example saying you're happy for these funds, provided that the gift document allows you to do it, to now be used for this big digital project or this big new reopening project, as opposed to that specific thing that you gave it for. A lot of donors have been incredibly helpful. So I just, hands up, another kind of caveat. Molly and I are not insolvency practitioners, and the reason why that is important is that lawyers normally, unless they're insolvency practitioners, will not give written advice or clear advice on whether an organisation is insolvent, partly because the stakes are high. It is one of those rare times where the personal liability of incorporated directors or trustees for incorporated entities, so typically the trustees of a charitable company or a CIO, could be personally liable, but also because it's a very factual and technical test, and it's far better that you have an insolvency practitioner who advises you on that, who knows how it would be treated in a court if, for example, a wrongful trading claim was brought. But in very broad terms, in layman's terms, there are two ways to be insolvent, and that is to fail the cash flow test or to fail the balance sheet test. So the cash flow test is essentially that your charity, in this case, cannot pay its liabilities as they fall due. So regardless of how much of the assets you may have, you do not have enough, or enough that is readily available, to allow you to pay your liabilities as they fall due. So in other words, you've run out of cash, and that is going to cause issues for you. If you can quickly liquidate assets and then convert them to cash, that will obviously help with that test. So that's one test, one way of being insolvent. The second test is the balance sheet test, and that is when looking at all of your assets as recorded and in truth as they really are on your balance sheet, then comparing them with your liabilities, you come to the conclusion that the liabilities are outweighing the assets. So a failure of either of those two tests is a potential insolvency situation, and you obviously want to be seeing that point in time well before it happens. It is really important, if you think you are approaching that situation, that your trustees and the executive take professional advice. And that is because there is an offence, a statutory offence, which is a breach of the wrongful trading duty. And essentially, in layman's terms, if a director, so in this case, a trustee of a CIO or a charitable company, continues to trade when they knew or reasonably should have known that they were not going to be able to escape insolvency. So it's not about the point you are becoming insolvent, but that you know it is going to come at some point. You continue to trade. And the reason why that is seen as bad and an offence is because you are not fairly then treating your creditors, including your employees and the other people that you owe money to. You need to be particularly careful about making payments to any of those creditors if you think you're getting into that situation, or making transactions at an undervalue, which is a particular issue for charities that might make grants, for example, to another organisation, a partner performing arts organisation, because you want them to continue with something. That is a very risky thing to do if you might become insolvent. COVID legislation was brought in March, I think, which dealt with a number of themes, including how to hold general meetings, but we don't have time to go into that today, but also around some of the central themes of insolvency. And there was a cessation, a reprieve of the wrongful trading liability for a period of time until the end of September. This legislation has been extended, but that particular suspension was not extended. So that the suspension essentially said that wrongful trading claims could not be brought by creditors from a period of time to the end of September. We thought that might get extended to end of December to give comfort to trustees, but it wasn't. So wrongful trading is still very much a live issue. So if your board has concerns about it, please speak to a lawyer or an insolvency practitioner about taking the written advice to know that you're acting and ceasing trading if you need to at an appropriate time. The insolvency test is often treated as going hand in hand with the going concern test, but they come from a slightly different place. The going concern test is all about how you as a board sign off on your accounts for the year, and also strongly relates to the auditors and their report and what they will suggest. So again, I'm not an accountant, but as I understand it, there's broadly these three outcomes that can occur where you are potentially in financial difficulty, which is that the accounts state that the organisation is a going concern, i.e. can continue to trade, and there's no material uncertainties around that. Then there is a secondary option, which is that it is a going concern, but there are material uncertainties. And this is the one that we think will come up relatively frequently for a lot of cultural charities. And then there's the third option, which is that it isn't a going concern. And the onus is on the trustees to also be confident about the going concern, particularly looking at the next 12 months. So it can be stressful, and we know that there are a lot of boards who are both going through that and working with the auditors as they come up to their account filing deadline with the Charity Commission. And it's important for the board to be across that and confident enough about the issues and the strategy for recovery that they will also sign off on the accounts and pass a resolution around that. And the middle situation there, so a going concern basis is appropriate, but there are material uncertainties, which is one of the obvious outcomes for a lot of cultural charities. If that is the basis on which your accounts are filed, the auditor's report will make that clear, and the auditor will be required to file a report with the Charity Commission, as Molly noted. It's a report of material significance. And so if that is coming, that is why we were saying it's good to be on the front foot with the Charity Commission, because you may need to be engaging with them anyway. So the last point we wanted to talk about, and I appreciate that we are tight on time, is around crisis decision making. I don't know, Tom, if it's worth me now sharing my screen on that, or if you wanted to ask some questions while I quickly set that up so we don't waste any time, because I appreciate we're nearing the hour.
That's fine. The one question that comes up there is, what's the impact of qualified accounts on other things, funder relationships, or does it have any kind of contractual impact on organisations if they file qualified accounts?
Yeah, so it's all public, it's public record. And if you're putting in new funding applications, you often need to put in the last 3 set of accounts. So the funder will know, and the funder, if they're doing their job properly, will ask about that. So absolutely, it could affect future funding applications. You also sometimes need to make declarations to the funder, depending on the funding terms. And also current funding agreements may have obligations in there about reporting any concerns that you could cease trading, or reporting any qualification to the accounts, or any professional advice you've had in relation to insolvency, and etc. So absolutely it does. Probably no massive alarm bells for a lot of relationships, but it is something that will have an impact on funding, or could do.
Yeah, thanks. And the other question I have was about using the power to alter restricted funding, and the sort of timeline that you are talking about if you need to do that. Sort of how long? I assume it's probably a ballpark, with Charities Commission being inundated with such kind of requests at the moment. But how sort of long does that take?
Yeah, I mean, I think as you say, it's really hard to tell, and the Charity Commission are not willing to commit to any specific time frame. My understanding is they're like, whenever you kind of the immediate bounce back you get when you kind of send these type of applications is that they will aim to get back to you with kind of an initial response, which usually isn't a substantive response, but in 40 days.
Well, so our firm, because we were across the charity sector getting so many questions about financial difficulty, what to do about insolvency and going concern concerns, what to do around making decisions about potential closure, part closure, merger, we came up with a relatively simple and free decision tool, which is available on our website, and the link is on the slides and will be sent round. But it asks a number of questions, firstly around, and then leads you through to a report at the end. But it really encourages organisations to get into the nitty-gritty of what you may be able to do to better your financial position, which obviously will then have a bearing on the going concern test and potential insolvency or other drastic decisions that you might need to take. So just to give you an example, a lot of it is tick box, but it's meant to be drawing on all of the different themes as far as we can kind of think of it as being applicable to many organisations that we would think of if we were on a board or at the helm of a charity that is potentially facing financial difficulty. And so it's a practical test. So, for example, this is one of the second questions that comes up. It's asking you about whether you'll be able to pay your debts as they fall due. So are you going to run out of cash over the next 12 months? But then encouraging you to think of all of these different themes, such as, I don't have time to go through them all, but selling assets, or applying to get restricted funds changed, as Molly was talking us through, the use of the premises, or generating income in other ways, or entering into sponsorship deals. And it's worth saying, Molly and I were talking yesterday, that one thing we have seen is that in some areas, corporate sponsorship and donations and a relationship with corporates has held up, and those sorts of agreements are still being entered into because some corporates want to align themselves to the recovery of the arts and the saving of the arts. And there's lots of other questions on here about the insurance and reducing costs around staff and so on. So if anybody's got any questions about that afterwards, please do email us, but it's meant to be a kind of practical tick box thing to take you through a number of questions, and then it amazingly, at the end of it, it will give you a report that you can then go with to your board and talk through, and it will probably talk about a number of options that might be available to you.
Great, thank you very much. It looks like a very, very useful tool, one for people to help guide their thinking a bit at a time when chaos reigns.
Yes, exactly. Exactly, that's the point.
That's great. No, so I think that's us for this session. So I'd like to thank Erica and Molly for speaking. It's been absolutely very useful for a lot of people and for me to pick your brains. So thank you very much. So Theatres Trust is running a few other sessions in the future, which you should keep an eye on the Theatres Trust website for information about. I'd like to thank the Garfield Weston Foundation, who've given us some funding recently to help deliver this, and other organisations like Bates Wells on our skills bank, who have been volunteering their time to help us support theatres during this period. So thank you all very much for attending, and do get in touch if there's any other topics which you'd like to hear about as theatre operators, particularly if you want to hear from an insolvency practitioner specifically, because that was flagged as something that some specialist advice might be helpful. So if there's anything like that, then please do get in touch. Otherwise, thank you very much for attending.